Good afternoon.
Good afternoon.
Y'all
Good
supposed
afternoon.
good afternoon to all. Great. I didn't realize on mute.
Hello?
Yes, you're
Hi,
in class.
Oh, yes. Sorry, I drive. I'm trying to help get home.
Okay, all right. He's trying to hurry up and get home. So how's everyone?
Everyone's fine.
Doing pretty
Feeling
good.
A little better now after seeing those grades. Feeling a little better.
Okay. So before I even move on, any suggestions for the final?
Short answer questions, please.
Can you let us know, I guess, in general, where I don't know how well the group or not well the group did overall, but how did you feel about the different sections, multiple choice versus short answer?
You mean how I feel, or what, or what were the
What the results were like?
Okay.
Hi,
I
is
think
anyone talking?
multiple
Because I'm
choice needs to be on
but
that.
I'm not hearing anything.
Someone said multiple choice. What did you say?
I'm Veronique here. Good night, everyone. I think it should either stay the same or multiple choice need to be on that.
Oh.
Yeah, multiple choice got to be on that for sure.
Yeah,
Or
so.
stay
I
the
don't
same.
have any sound. I'm gonna come out and come back in.
Yeah.
All right. Multiple choice must be on it. All right. So let me see. I heard Veronique Mout just now. She said multiple choice must be on it. Oh, okay. That's what you say. All right. So multiple choice. You all asked for 70. I gave you all 70 plus 1. Agreed? Overall,
Yes, you did.
overall,
Yes, we did.
the top of 70 is 35. Three persons. 4 persons got below 35. 50 and below, not including the ones that got below 35 or below half. So 50, between 35 and 50. 1, 2, 3, 4, 5. 5. And over 50, there was, I don't have them in by numbers. Over 50, there's 1. Hold on, should be 1 more. Let me say 1. Yeah, 1 person got over 50. Over 50. For the short answers, which was out of 30. 1, 2, 1 person, let me see. 1. Let's go over. Let's go 20 and above. 20 and above was 1, 2. One person got 30 out of 30. 3. 2 persons got 30 out of 30. So that's 4. 3 persons got 30 out of 30. So then there were 4 between 20 and 30. And most of the rest were below 20. Okay, next question.
Ms. Archer, what was the highest grade, please?
The highest grade, hold on, where's my paper? I just put my paper over here. The highest grade was 83.
Sorry. Logging, what was the lowest grade?
Okay, and the lowest grade was 29.
Well, we get some work to do.
And we got plenty of work to do. That short answer, I know they're doing a short answer. I even answered one of them. So I know the short answer in it.
And I don't know why. Some people just didn't answer it. Don't ask me why. I mean, I gave you
Well,
all the
I can speak for me. I can speak for me, Ms. Archer. And Krista can tell you that day was a rough day for me. I had a massive migraine all day. So I really was trying to rack my brain to finish those, at least the short answer questions. But boy, at one point, I just couldn't take no more. Because Krista said, I was even shocked when I see you leave. I said, I wasn't finished. I just could not take no more.
Yeah, because I'm looking at it right now and you just started. So I just gave you points because you started. But I could
Appreciate that. But I tell her I really didn't have any more to give because I really tried.
yeah, I saw that. But I know Krista was all concerned about her paper. Krista,
Yes,
yes, you fell down on the multiple choice.
I figured as much.
Yeah. you
I knew,
fell down.
yeah, I went through, you know how we do. I went through and counted which ones I was sure I was guessing on and which ones I really wasn't or wasn't really given a decent guess. And it worked out to be almost what I fell short on out of 100%.
Okay, all right. And then the last essay question, you didn't answer that one right either. You went off course.
Yep. And I know exactly where I went off course.
Don't do that in the final, please.
I will not. Yes,
Okay.
ma'am.
I need to first understand I'm not understanding the essay questions at all. So that's why I'm timid and afraid of those. I'm going to be upfront and honest. I can't
Great.
read the cases, understand the cases like that. So I said, instead of writing a bunch of foolishness, I just might as well don't answer them at all. So that's
Okay.
my take on it.
I looking at yours. I see where you attempted, and your attempt got you some points, right?
Mhm.
What I can tell you to do is, for homework each week.
Mhm.
So
Uh-huh.
starting tonight, this week, send me the first question. I'm gonna send
Okay.
it to you. I'm gonna send it
Okay.
to you, and I want you to answer it.
Okay.
Now, when I sent you the cases,
Uh-huh.
based upon when we had the discussion, you should be able to align the cases with the subject matter of the exam question.
Okay. Okay.
Because a lot of people did it and they aligned it and they got good points. So don't be
Okay.
afraid. Because if I tell you the first question was on the 3 criterias for quieting a title, and I gave you the cases, you align the cases to what I said the question is about. So when you open it, you know exactly, and then I gave you 2 for each question. So some people who would have actually presented one of those questions, they went to town. They wrote like 4 pages.
Ooh, wow.
Right, but I didn't expect that from everybody, but I expected you to be able to answer the question.
Mhm.
So don't be
So-
afraid. You just have to practice it.
But even with the
Yeah.
multiple questions,
Go ahead.
are you gonna go over them or give us the right answers or whatever? So I mean, for the ones that I know, I guess I try to. I don't want to go and guess the wrong answer again in the final.
That's if you all want multiple choice.
But can we get the answers for those multiple choice to study?
Yeah, but that won't be a part of the final exam though.
Are
The
we,
final-
are we able,
Those
sorry,
are all.
are we? Sorry, Ms. Archer, are we
ahead.
able to get our papers back at all so that we could see what we
Yeah, I could have
were
Mr. Brown.
correct?
Yeah, I could do that.
Okay,
Yeah, I'll ask him to scan these to you. That's not a problem. I was going to, and I remember we had class. I said, let me hold it in case people had questions. So, yeah, I have it.
Somewhere in the middle, but I know I didn't.
You know, Miss Archer, what I
Go
did I
ahead.
realize some of the, like, I got some pointers, and that's why me personally, I particularly like multiple choice, because some of the questions that you ask in those multiple choice, you could kind of get information from them. You
Yeah.
understand? So
Uh-huh.
that's one of my rationale behind it. I am not a short answer person. I will try my best, and I will take the examples that you give me and back and forth and try to line up the cases. But
And then you much easier than
yeah,
trying to study at least 6 to 7 chapters.
okay, yeah,
See what I mean? Because
Yes.
in the final exam, I'll give you 5 questions. I'll tell you what those 5 questions are about. Where case law is relevant, I will tell you the cases.
okay,
Whether 5 or 6 cases, and then I normally throw in 1 or 2 bonuses based upon what the results are.
okay. But please, Lord, don't let the whole be short. Don't let them be short answers.
What?
You're saying not that the whole exam, right?
Yeah, I normally give 5. The class normally after they ask for these multiple choice, when it comes to the final, they just want the 5 essays. So it's up to you all. They don't want those multiple choice. But you have time to think about it because I haven't written it yet.
Okay.
You could think about it.
I agree to do a mixture. We did a
Yeah,
percentage
mixture.
wise.
Yeah,
Yeah.
Just don't like short choice and just don't
I
like
think
short
mixture.
answer.
combination, yeah.
I think so. Even if we go to the half, 50-50.
No, 50-50.
No.
No, 50-50.
But
For me, sorry, good evening all. For me, the multiple choices are just so close. And so you're either right or you're wrong.
Yeah. It can't be no less than 50-50 we both.
That's what I'm saying. I think it's fair for 50-50. Some of us like short answers and some of us like multiple choice. So if it's 50-50, then everybody wins.
But then everybody can get 50 at the end.
This is my point. So if you miss your 50, you don't lose.
Let me go in there. That's it. I gotta go back. Take that.
The passing grade is 70. So let's just say
You can do
You-
it.
40. So how much?
Take too long.
Are we able to use the grades from the exam that we did?
The midterm?
Yes.
Yeah, the midterm go with the final.
Okay, great.
Yeah, the midterm go with the final to get you your 70%. So don't forget it'll be an average. Just between the two, you add the 2 together and divide by 2.
Miss Archer,
Yes.
so that means if I get 29%, I have to basically get 100 on the exam to make the 78.
Almost.
100
Almost.
almost, that's like I have to make 101%.
Well, you can,
That's why I
you,
said a lot of work to do.
there's no
But-
need to, you can,
Miss-
however, if you wish, you can set a supplemental exam.
Pardon me?
I said, if you wish, you can take,
Can take a what?
Yeah.
You're
After you
breaking up, Ms.
run
Archer.
back.
that can be done.
You were breaking up, Ms. Archer.
Oh, I was saying, for those who got,
I think it's someone else that needs to mute their thing. I think
Yeah.
that's interference.
okay, I was saying for those who got, let's say below 55, if they wish, they can do a supplemental exam. You let me know.
What's the date of that exam?
I haven't decided yet. You have to tell me if you want it.
Yes,
Okay,
Yeah,
so, all right, so we could do a supplemental exam. When is it convenient for you? Which day of the week? And which week? Where's my calendar?
would
Which
it
days?
be on the same chapters?
Yes,
Okay.
the exact same chapters. So why don't all of those who want to do the supplemental send me an email after class. I will send you the first scenario question, and I want you to answer it.
Okay.
And then
Ms. Archer, could I get that third question as well?
you want the third one? Okay, hold on,
Yes,
let me make
please.
the third one for you.
Okay.
Third for Krista. And the first for the resets. Okay. I could do that. You want to take this 2 weeks from today?
That's fine with me.
Yeah, that's fair, that's fair.
That's
Okay.
fine.
So what's today's date? March the 6th. So next week will be the 13th. So that'll be the week of the 20th.
Fine with
Yes,
me.
ma'am.
Okay,
Yes.
which day is good? When you all
That's
took
a
it,
Monday.
when you all took it on a Monday?
Yes.
Yes, another Monday.
Is that you talking about the final? Are you talking about the
No.
final?
No, just the reset.
No,
The reset.
Supplemental.
The supplemental exam. But let me ask them which day is available, because you don't want to miss the class on the 20th. So let me see what they have. Which days are okay with you all? Give me
That's
some days.
just, I don't understand what's happening, Sacha.
Okay,
Depending on your grade, if you want to reset the exam, she's giving us that option. We just
Oh.
need to decide which day.
If
Oh,
you
okay.
got below a 55.
uh-huh.
Reset it or getting additional questions to like add to it.
Additional
Yeah.
questions?
Reset
Okay.
to try and get a better grade.
Yes. And for those who wish to practice the scenario, they can send me an email after class. I will send the first
Yes.
question so they can do it
practice.
for, if it is not right, I'll send it back and say redo.
Yes, okay, fair enough.
Okay.
Okay, so which day through the week on the 20th is a good day? Give me 2 days so I can put it to the office.
Start Tuesday.
Tuesday.
Me too.
Tuesday or any other day?
Yeah, any other day works for me.
Okay, so let me see what they say is available, and I'll let once everybody who's taking it sends me an email tonight, and then I'll tell Mr. Pratt, these are the persons. This is the week that they want to do the supplemental, and ask them what's available and tell them preferably the 21st. All
Okay.
right? Hey, everybody happy now? And then I'll
Yes,
ask them to scan these to you. Scan.
thank you.
Sure.
Very happy, thank you.
Exams. All right, so
Ms.
You'll say-
Archer, Ms. Archer, for those not sitting it, then we'll just have the regular Zoom class?
No,
Or
they
it's not a class day, that's an off day.
It's an
They'll be here.
off day. Tuesday's an
okay.
off day.
Off
Okay,
day.
okay.
Any- No. So we'll say congratulations to the student that had the highest grade. I don't think they wish to be announced themselves.
Thank you, Ms.
What was the
Archer.
second highest? What was the second highest, Ms. Archer?
Well done, I must say. They were listed for a reason. The second highest was an 80. So the highest was an 83 and the second highest was an 80.
Need some smart folks.
Yes, they did. So they wish to remain anonymous, so I'm not saying anything. Yeah. And let me see if both did the same in the same area. Because I can't remember off the top of my head. Yeah, both did very well in both sections. They were very close. Both of them were very close in terms of numbers for the multiple choice, but both of them got full points on the scenario questions. Yeah.
Ms. Archer, just a quick question with the scenario questions. When you look to do the markings, you're looking for full detail, date and time, that sort of a thing, or?
No. When you write your answer, when I read it, I know that you understood what we've been going through in class. It's not verbatim.
Okay.
No. Each one of these were written differently, but I could tell when students went off in a different, talking about something totally different. Because it wasn't on the question that I asked. So it's not dumping the whole case. It's answering the question.
Right.
And then I don't know, maybe some people ran out of time, or like some said that they couldn't answer the last one. But I mean, everybody knows when you're talking about the court reversing a certificate of title, and we did at least four cases on that, they were based on fraud.
Right.
So you couldn't be talking about certificate of title and you go in and talking about all kind of other things.
Right.
Because the question was only based on, the answer for that is only on fraud. So you can't put in it fraud and then put in it trespass, because the question wasn't related to trespass.
Right.
Was the first one. This one was talking about fraud.
Right.
Yeah. So that's what I'm talking about, answering the question.
Okay.
But if someone, if you want to practice a question, just say not taking the reset or just put practice. I can send you any one of the questions you thought you didn't do well on, or ask me which one I say, let's say whichever one I didn't do well on, can you send me that question to practice?
Okay, I guess we'll have to wait for the individual return of the paper to see the markings.
And just tell me which question you want to practice.
Okay.
That's fine. Yeah, that's
Sorry I joined late in terms of talking
no,
about the reset.
no, that's fine. That's
Okay.
fine.
The
Not-
reset is just going to be the questions that you're going to send, or is it the whole multiple choice?
No, just a scenario question.
Got you.
No. For you to sit down and do another exam with a bunch of multiple choice, that means that you're gonna have to sit down and restudy all those chapters.
Got you.
Yeah, no.
So let me ask them, Ms.
Mhm.
James' sake. If
Yeah.
you reset the exam and you take the better of the two, or
Now I'm gonna add points.
I got you.
Yeah. Now, if you want the better of the two, I could just give you 5 questions.
No, I meant the better of the midterm versus the reset.
Yeah, that's what I'm saying. It's different ways you can do it.
Okay,
I can write the exam whereby I give you the difference between the highest grade and the lowest. Or I could use it the cutoff point wherever you are now and mark you according to that. Or I could just scrap the midterm that you did below 55 and give you a brand new exam.
got you.
So which do you prefer?
I'm not in the category, just asking questions.
Oh, okay, all right.
Because I would like my grade to be better, but that's why I ask.
Oh, let me see where you at. Well, you're not far.
No,
No. You're not far.
okay.
No, you don't have to worry about that.
I
You'll
know.
make it in the final.
Okay. All right, thank you.
Yes. Any more comments? Those I have not heard from? No? Everybody's happy now? I hear nothing. That means everybody is happy. Mm-hmm.
Yeah, we're happy. Happy.
I'm glad. Okay, so today's supposed to be Unit 6 when we will talk about the mortgagees, duties, liabilities, and rights. Did everybody read the chapter? Say
Yes.
yes.
Attempted to.
Yes. Yes.
Be honest, this
Yeah.
week, no.
But this chapter is a little bit easier because it's referring to you as the bank
Yes.
and what you're responsible for as a banker. So I figured that this is a better, easier read for you because it's talking about what you do every day.
Judges, also all of us in this area now.
No,
We're all in different areas.
majority.
Yes, so true.
So we all know that in a bank, the whole relationship is contractual. Banking law is based on contract law. So the first thing about the banker-customer relationship is that it is contractual. And that relationship is one of debtor and creditor. When you obtain a loan, then the relationship is in reverse. And once you enter into that relationship with the bank as banker and customer, there are what we call implied and express terms. Those express terms are laid out in that contract. The implied terms come from common law, from case law. So as a bank, there are contractual duties. And those contractual duties arose from common law cases. One of the main duties from a contractual nature is that a bank must have employees that have the requisite skills, have carry out the proper due diligence, and they are expected to be at a higher standard of care than a normal person. And that's why you all are in this class. Bankers also have a duty to make sure that they are not negligent. And that's why it's very important that when you give advice to a customer, that you give the correct advice. Because if the customer relies on that advice and they incur a loss, they can sue the bank. So between a banker and his customer, there is what we call a fiduciary relationship. And that fiduciary relationship arises by common law. There's no book or no document that you sign as a bank or as a banker to say that I have a fiduciary duty. It arises by the profession or by the institution that you are a bank. And by being a fiduciary, it means that you have to be loyal to your customer. As an employee to the bank, you have to be loyal to the bank. You also must be confidential. And there must be trust. So as an employee of a bank, you have a duty to abide by being trustworthy and being confidential and being loyal to your employer. If you're not, then there can be a breach of your fiduciary duties. If we're talking about you as an employee, that could mean that your employment contract can come to an end if you breach certain duties. Now, that duty of confidentiality is based on the common law case of Turnier. And in the case of Turnier, what the bank did was that it disclosed to its customer's employer that he gambled. And the customer sued the bank for breach of confidentiality. And in that case, it established that there are 4 exceptions to the duty of confidentiality. One is when there is a request by law. That's why it's called compulsion of law, which means that it could be either be from the Attorney General's office, it could be from another foreign jurisdiction, it could be from the courts. When a request comes by law, you have to answer. There is an exception if the request
We can't hear you.
for information is in the public. Not how
Hello?
She went out.
come. When let me look in the chat. Let me see.
Yeah.
Can you hear me? Okay. Where did you
Yes.
stop? Where did I stop?
Two
When you,
minutes.
okay,
You
so
were
should I
talking
start
about
back?
the 4 exceptions to, you're talking about the case of Turner or something like that.
I was talking about the duty of
Exception.
confidentiality, yes. And that there are 4 exceptions. One is under the compulsion of law. Remember, that's a request from the Attorney General's office or from a foreign court, or it can be from the local courts. The second exception is when it's in the public's interest. And normally in the public's interest is normally during the time of war. The third one is when it's in the bank's own interest. So that could be when a bank itself sees that there is something suspicious or untoward going on in a particular account, and they want to make sure that they protect their reputation, they can disclose. And then the last one is disclosure with the customer's express or implied consent. So that's why customers, when they sign any agreement with the bank, they're supposed to read the contract, because the contract would have in it express consent provisions. The implied consent arises from common law. So in the Bahamas, our duty of confidentiality is not just from common law. We have actually legislated it. So under the Banks and Trust Companies Regulations Act 2020, the newest one, under Section 77, it is no longer called the duty of confidentiality. It is called the preservation of confidentiality. And in that section, it speaks to what the bank or trust company or credit union or private trust company or money service business can do. And it says that if you are a director, an officer, employee, or agent of any one of those financial institutions I just called, or if you're an attorney or an auditor, you have whatever information that comes within the act of your employ or in the act of your contract, you have to keep it confidential. Even if you are a branch or a subsidiary of another entity, and you are here in the Bahamas reviewing documents, again, it has to be confidential. It also speaks to the inspector can, from time to time, approve information to leave the Bahamas from here to the head office, but it can only be for collation, a processing. No names of clients can leave the jurisdiction.
What was that? No what can leave the jurisdiction?
The names of the client can leave the jurisdiction.
Okay. Break up your son.
Oh, okay, okay. It also, the legislation also provides for the central bank to speak to other regulatory bodies. And you'll see sometimes that they send out joint documentation. The central bank can also speak with other central banks around the world and establish what they call memorandum of understanding. But doing all of this in terms of preservation of confidentiality, the act also says that nothing in section 77 prevents a licensee from providing upon a legitimate business request in the normal course of business, a general credit rating. So even though you have all of this duty of confidentiality, the law still provides that you can give clients certain information. And you can't prevent the inspector from sharing information relating to assets and liabilities and transactions with the FIU. Other than that, the offense, the fine is $25,000 or 2 years imprisonment or both. If you violate section 77 of the act. Now, traditionally, based on common law, the rule was that a bank is always required to provide a statement to the customer periodically. But the customer wasn't obliged to check that statement for errors and omission. But times have changed. And things are based on practice. So where's my list? Who's supposed to do Macushla Pinder versus Scotiabank Supreme Court ruling?
That would be me.
Okay, all right. So tell us what happened in that case.
All right, no problem. Okay.
Very quiet tonight. Why is that?
Pardon?
You've been very quiet tonight. Why is that?
I was just sitting back and listening. I am enjoying the class as it is. Quite hungry as well. And
We
just,
all are. We all are.
yeah, that's it. I was waiting for my little moment now. So
All right. It's your moment.
thank you.
Okay.
But yes, I got thank you for this nice long read. It's about 80 pages for anybody who's interested in that fact. But this case, it was pretty interesting. The plaintiff there would have been Ms. Pinder, and the defendant, of course, is Scotiabank, and this was before Justice Keith Thompson. The main issue really here was a matter of missing money for one part, but it was really based on a claim that Ms. Pinder made that the bank breached their fiduciary duty, as we were just talking about, and they breached their contract with her due to breach of terms of their personal financial services agreement, the PFSA. And as a result of these, she lost some money. The monies that she actually lost, based on her claim, amounted to $27,500, and the interest from those monies and the loss of use of those monies. So those things were the things that she actually claimed. And this tender actually pleaded to the court for the return of those funds, interest on the money, and any further and other relief as the court would have deemed just. So with these claims raised against the bank, what Scotiabank chose to do was raise some defenses to these claims. And one of their, in their defense, first and foremost, they outrightly denied most of everything that Ms. Pinder was saying, especially in regards to the breaches of fiduciary duty and with regards to breaches of contract. And they further went on to claim that Ms. Pinder was actually negligent, and her negligence really and truly led to her losing some of her funds. Now, when this was all laid out before the courts, evidence was presented from Ms. Pinder, from Mr. Relminis, who was an assistant manager at the bank, Mr. Alonso Pratt, who was a branch manager, who was at the specific branch where Ms. Pinder held her account, and Mr. Edward Smith, who was the chief investigator of the bank. In the evidence presented, Ms. Pinder showed that she went to the bank sometime in February, I think it was 2016, and went to actually get her book updated and check some of her transactions. And at this time, this is where she actually discovered some issues and discrepancies in the funds that were coming in and out of her account. At this point in time, after going into the branch, she realized that there were regular ATM withdrawals in the amount of $1,000 or so at a time coming out of her account over various periods. And one of the most alarming things about this whole situation to her was that she was actually out of the country at the time when a lot of these transactions were happening. With her presenting this case to the bank, she also, like I said, went to get her passport updated, and she was then informed. I can't remember this part at least too clearly, because the passport thing, I think that's just so far in the past now. But she was informed that the passport basically was being done away with, and everything is moving more to the transactions and monitoring through the ATM cards. But in the end, she brought her claims to the bank for this first round of actual loss of funds. And she presented those claims to Mr. Pratt, who was her branch manager. And from there on, she really left it. And a couple of months later in the same year, in November, so she went back in to just verify some things on her account and discovered yet again in the months of September and some other periods that there were some additional charges and transactions coming from her account. And in total, she calculated everything on her basis to about $34,500 or so. And at this time, when this happened the second time, Mr. Pratt had informed her that she needed to present this in writing to the bank, as well as instruct the police to provide or to begin a financial investigation in this matter. And this is where Mr. Smith, who was the chief investigator of the bank, stepped in. And upon the bank's review of everything, they considered or they realized that everything that was coming out of her account was due to ATM transactions. Now, this was interesting mainly because in court, no one was able to sufficiently prove to the judge under the examinations that the statements in fact showed that the transactions were ATM transactions as the bank had claimed. And based on the evidence from Ms. Pindler, she said she never used those, made those ATM transactions because at some points when the transactions transpired, she was out of the country, as well as she made it known or stated in her evidence that she rarely uses the ATM in question where a lot of these transactions came from. And there were points in times when she had actually lost her card, as well as she got a replacement card and when the first situation had transpired. However, the bank held firm to their claim that everything was ATM based and everything was authorized by use of her own personal PIN. Now, after all of this evidence was presented, the judge then went on to provide his rulings and just provide a lot of the law on the matter. The breach of contract was actually accepted by the judge by using virtuous exceptions of the financial services agreement, which really spoke to monitoring the accounts and some things that the bank actually should be doing in the event of any kind of strange transactions actually happening. Breach of fiduciary duty was also accepted and laid out by the judge. The judge also leaned on the Financial Transactions Reporting Act 2018 to establish additional contractual duties of the bank, especially when it relates to risky behavior. And I think it was in Section 12 or so that really speaks to just doing proper due diligence for an account under banks. And the judge then leaned on statute law to qualify basically one of the major things there, which was a matter regarding reasonable notice with relation to the changing of the account from a passbook account to a standard ATM account. And it was really in this area where the judge really established a lot of the breach of contract matters as well. And the judge also denied that the bank proved sufficiently any negligence on the part of Ms. Pindler. And as a result of all this, the bank ordered that the sum of $27,500 was with interest, along with damages and costs, were to be paid to Ms. Pindler.
Okay, so now the bank has general duties, general rights, and they arise by law. And when you sign a contract, those rights are in the contract also. So they have a right to charge a customer reasonable fees, as long as under the Banks and Trust Companies Regulations Act, they give adequate notice. They have a right to demand repayment for any loan or any borrowings, any overdraft. They could put a lien on any of your securities that you have deposited. They could be indemnified by the customer for any expenses or liabilities. Any checks that are unpaid, they can return it if there's insufficient funds. They can also exercise a right of set off, and they can combine accounts. So in the case of McCushla versus Scotia Bank, the one that Fountain just read, Someone tell me what are the key duties of the bank that arose in that issue? Because it also spoke about her duties. But what duties did the bank have in that relationship?
The bank was supposed to have notified the client of any changes.
You mean in terms of
Right.
moving from from
From passbook to ATM account.
mm-hmm. Yes. Fountain, did she say she was aware?
I know she didn't say that it was that is from the possible accounts because I was also laid out by the judge. The bank even went so far as to say that possible accounts don't exist. However, the PSF the financial you state something directly relation to possible accounts.
But the thing about it is what was contradictory was she did say when she gave evidence that she was aware of the card and she was aware of the PIN. So
Yes, she was aware of that.
right,
But
so you
she
were
still
the card,
claimed like it was a
right?
possible account.
Yeah, but the passbook account is a thing of the past.
I agree. It was
So like her evidence, it just didn't line up with what
not
is
at
the
all.
no, it didn't line up with what is the what is her duties as a customer and what is the right of the bank. Because I am sure this case is the only one I've seen. So I am sure there are other persons who had passbook, maybe 20, 30 years older than her, who are aware that there are no longer any passbooks.
Yeah, but didn't he also say that the bank could not produce evidence that the withdrawals were ATM withdrawals?
Apparently, Fountain missed that part. The head of security, they showed her the videos and she said she didn't recognize the people in the video.
But no, yes, they did say they did show some videos. I didn't state that in the information. It was actually a specific question put to I think it was Mr. Pratt. And the cross examination, they asked him if he can show on the statements, not on the actual videos. Because
Okay.
the bank was relying on the statements of the account just to basically state that they were ATM accounts along with those videos, ATM transactions along with them videos. So I believe that kind of created a bit of discrepancy in the eyes. If they simply went with
So
videos,
the
they might have had a
statement
better
then should have
chance.
specifically say ATM withdrawal, and that didn't happen.
Yes, they couldn't show that on the statements at all,
Okay.
but they were able to show some kind of videos of the ATMs and
Okay.
individuals at the ATMs. Some
Okay.
always denied that she well, she said she didn't know who was person.
Right. Yeah. So anyhow, she won in the first instance. Okay. So her duty as a customer was to pay reasonable charges, only issue checks if you have sufficient funds, exercise reasonable care if she's drawing checks, and to advise the bank of any known forgeries. As a customer, she also had the right, and that right is the right to repay funds deposited on demand, to have the bank discharge its duties to her, and the right to have funds deposited and appropriated to the account that they're earmarked for. Now, you could hear between Fountain that there were really some discrepancies. So Krista, what happened in the Court of Appeal? Because the bank appealed this case.
I've not read that, Miss Archer.
What? You
No,
missed the
ma'am.
best part.
No, ma'am.
Oh, man.
Can I come, sorry, could I come back with it?
Yeah, you can,
Okay.
because it is long. But
Yeah.
in the Court of Appeals, she lost the case. The bank won. And
Ms.
they
Archer,
went a different route. Go ahead.
I'm sorry, I was
How
listening
is
to,
that possible after giving a ruling?
the thing it is, I think in the Court of Appeal, and not reading the Court of Appeal, but just listening. She was awarded in this court. However, the bank do have, I mean, if they could have produced the ATM, because if she had her own personal PIN and it was evident that it was used through the ATM, ain't nobody else supposed to have a PIN. The bank doesn't even know her PIN. So to go,
Well, you hitting on a good chord. You hitting on a good chord. Yes, keep going.
yeah, so, obviously, let's just assume, because like my years of banking, I have seen it all. I think I've seen it all and then something else appears. But, she holds her PIN. She's responsible. If she give her PIN out to somebody, that's on her. You know, so if somebody else is using the ATM, which is supposed to be a personal PIN being held by her, so if any withdrawal or any transaction to that, having entered her personal PIN, then the onus is on her to prove that, she said she was off the island. Somebody had to have had a PIN that she would have disclosed with them, and so that would have breached a contract with her in the bank, and so it would
Yeah.
have been on her to prove the point that I did not.
See, and the funny thing also, when you read the Court of Appeal, the Court of Appeal case, she had her card and her PIN. When she reported it the first time, Mr. Pratt gave her a new card, which she repinned. So how could this person
Happen again.
it happen again? Yes.
Yeah.
That's,
To
she
me,
kept
when I
that
read
somewhere.
that, right.
She had she had a responsibility to secure her PIN.
Yeah, but if you
With-
just change it, how would someone know what it is?
I mean,
Exactly, even her
she's
first
putting it in the
PIN.
same place. She used the same PIN and put that card the same place. So whoever used the card the first time, probably
She-
used it the second.
She placed a sticky on it. I'm just wanting to know, you know.
It doesn't say, but to me, I think it is someone that she knew.
Yes.
And she just didn't want to say who it was, and she just wanted to get her monies back.
She gave a PIN out, so even if she know the person, she had to have shared it. So if she shared with a boyfriend and now they broke up and now she won't blame the bank, you know, that's sort of the thing, that he still remembers her PIN and has her card. And she don't know how to ask back for it. I don't know what's going on with her.
Or she didn't down to a science. She give it to her boyfriend.
Or husband.
my
Boyfriend, husband, she gave it to someone.
Someone
But-
don't know how to ask
Yeah,
back for it.
but you know, it's like when we read all the other cases, when we read them sometimes, like we normally, I mean, when I say we, I mean us, the class, we're trying to figure out how they come up with these decisions when we use it based upon our knowledge and experience in the field.
Mhm.
Because when I read it, there were just so many loopholes. I just couldn't see how they came to that conclusion at all. Because I don't think there's no one here who could walk around and say that they have a passbook and they expected they're taking their passbook to be updated in this modern time. This wasn't someone who was 80 or 90 years old.
Mhm.
This is modern time. Everybody knows there's no passbook. Everybody.
No passbook, and I'm sure she probably have online banking too, that she could have checked her accounts throughout. I don't know.
And most people who have online banking check their account every day, all day long.
Yeah.
So at that one, I couldn't understand it. I just couldn't understand it. And then after you got a second card, someone still used the card. How is that possible? everything just didn't line up. I couldn't, I just said, no, this is not making any sense.
I agree with you. I was quite lost for most of it. I had to start looking at the overall movement and then again coming back. Yeah, but
Yeah,
it just wasn't adding up.
Yeah, it wasn't adding up. Because that's like you saying that I had to read it myself. And I say something that's not right. I say, but hold on. She's coming all the way to court. And she's talking about a passbook. And everybody knows when the PFSA came out, which is a contractual agreement under the terms and condition. When the PFSA came out, passbooks were done away with. So I couldn't understand where that argument was coming from. I couldn't understand it. It was not making any sense to me. So I'll admit it too. I read it at least 3 times because I was trying to figure out what exactly is going on here. I couldn't get it. All right, I was looking for the Court of Appeal while we were talking.
I think I remember that case, wasn't she a Thingham too? A journalist?
Yes.
I remember that.
Yeah, the headlines was all over the paper.
Yeah, she was a journalist. I remember that.
Yes, she was all over the paper when they were talking about how she won the case. So they say here that the bank appealed the decision on numerous grounds and say that the judge fell into error of law and fact by failing to appreciate that on a true interpretation of the PFSA, that the respondent had other options to update her account. And by her failure to take advantage of those options, she failed in her duty to the bank, as well as that the learned judge fell into fundamental error and misapplied the law when he held that the applicant did not lead any evidence to support the defense of negligence of the respondent in meeting and honoring the terms of the PFSA. The appellant asks that judgment be set aside in its entirety, and the court heard the parties and reserved its decision. So the court said appeal was allowed. So they allowed the Scotiabank to appeal, and the judgment was set aside. It said the parties are invited to make written submissions regarding cost. So they said the respondent did not discharge the burden of proof, and the respondent is Ms. Pinder. She did not discharge the burden of proof to satisfy the court that the allegations in the writ of summons statement of claim were proven. Hold on. My things go dead quickly. It is fundamental to our system of litigation that the burden is on a plaintiff to prove its pleaded case. The standard of proof is on a balance of probabilities. The statement of claim does not identify what contractual term, expressed or implied, of either the 2 pleaded agreements which the bank is alleged to have breached, the material terms of an agreement which are relied on in a matter should be set out in a statement of claim. The plaintiff led no evidence that the withdrawals were made by a card other than her own, and the judge did not expressly make that finding. Moreover, Ms. Pinder did not bring to the attention of the bank that any withdrawals were improperly made until well after the withdrawals had taken place. Ms. Pinder had not pleaded, nor has she identified what term of either of the 2 contracts that the bank has breached. She has not adduced any evidence to show that the withdrawals were made otherwise than through the card, which the bank issued to using her PIN number. She has not led any evidence that the bank issued a second card. The claim for breach of contract on the evidence was not proven. Assuming that the withdrawals were improperly made, the issue is whether Ms. Pinder has made a case that the loss was caused by some breach of a term expressed or implied in her agreement with the bank, or as a result of some duty in tort owed by the bank to her. In the absence of any evidence that there was skimming, or another card being used by the bank, there is, in my judgment, simply no basis in law in holding the bank liable for the loss. In her agreement with the bank, the respondent, Ms. Pinder, accepted a responsibility to regularly monitor her account and to immediately report any improper transaction on her account. She had the ability to do so, but did not do so. It was that failure which caused the law. There was simply no evidential basis for the judge to find liability on the part of the bank on Ms. Pinder's pleaded case. And she, in turn, had to pay costs. Now you see the difference between the Court of Appeals rationalizing the case versus the Supreme Court. The Court of Appeals went on exactly what I just finished telling you. The bank has certain duties and it has rights. And the whole relationship is based on contract law. And the decision was based on that. So if you're coming to the court to say that someone breached a contract, then you're going to have to say which provision, which clause, which section, and then back it up with evidence. Any comments?
Only that I agree.
And she
Yeah.
lost some money out from her account, from whomever taking money, and she had to pay costs.
Yes. Yeah.
I
So that-
wondered how that judge in the first instance could have given her, ruled in favor.
Fountain, read that again. Fountain, read that again, how he came to that conclusion that
She should
She-
benefit from that.
yeah, she should benefit. Because I'm
Oh,
on my
this one was really, really convoluted in my opinion, but he tried to establish breach of contract by virtue of using sections of the PFS, which really just gave some light references to past accounting and monitoring of accounts. He also established just very loosely actually this breaches of fiduciary duty. He just accepted it, really, he didn't establish it. And then he leaned on the FDRA 2018, the Financial Transactions Reporting Act, just to establish some contractual duties in relation to monitoring the accounts, as well as I think it's mainly part 2 under the act. It was really talking a lot about risk aspects of the act, which I found just nonsensical. And then he also spoke to reasonable notice by using of some statute law cases, of a few, and some were actual recent cases by local cases by Justice Ian Wyman that just established that okay, the bank would not give Ms. Pinder reasonable notice that the account is going to be moving from this passbook account over to their ATM accounts. And he really and truly used these things to state that, and he said that the bank didn't prove any negligence on the part of Ms. Pinder. But the interesting thing is in the evidence, I think Ms. Pinder, and it was proven that Ms. Pinder actually did lose the card. It was proven in evidence that she did take too long to come and produce any of this information to the bank, saying it would take about 60 days, in some instances, or nearly 60, for her to come and actually take to the bank some of these funds were missing. But he just already denied that the bank proved any negligence on the part of Ms. Pinder in his opinion.
Yeah. There were 2 good cases. Miles apart. So if you have the chance, you can read it. So what's the rights of the bank as the mortgagee? We all know the bank has a right to possession, because we did that already when we looked at the remedies. So notwithstanding the right to possession, the banks are always reluctant to go into possession. And that's due to the inconvenience administratively and the potential liability for any negligence. The bank has the discretion to adjourn proceedings for possession of mortgage property, particularly when they're exercising their power of sale under the terms of the mortgage. The next right as a mortgagee, they have a right to the statutory and contractual power of sale. And under the mortgage loan agreement or the indenture of mortgage, they have the right to sell the mortgage property in the event that the borrower defaults under the terms of the mortgage. The statutory power of sale arises when the mortgage money becomes due. It cannot be exercised until one of the following conditions has been met: the demand for payment, followed by the default continuing for 3 months, or interest remaining in arrears for 2 months, or breach of some covenant. That's other than payment and interest. The third right that the bank has is the right to additional property. Since the mortgage of land includes fixtures and anything subsequently affixed to the mortgage property after the security has been executed, the legal mortgagee is entitled to the additional chattel. That means furniture and fixtures. The fourth right is the right to documents of title. The first legal mortgagee is entitled to all the title deeds, though the mortgagor may inspect and make copies of them at his own expense. An equitable mortgagee is not entitled to the title documents unless it's stipulated in the equitable mortgage document or the agreement. The fifth is the right to protect the property. Most mortgages contain terms regarding the borrower's obligation to maintain and insure the promised property. The mortgagee has a statutory and common law duty power to prevent deliberate damage, carry out necessary repairs, and insure against fire. It should be noted that if the mortgagee goes into possession of mortgage property to carry out repairs, it must account strictly for the work done. The right to insure against fire is only to the extent of 2/3 of the reinstatement value and does not cover other risk. Now, I know some banks have other requirements for insurance coverage for fire. Any comments there?
Can you repeat that, please? You could clarify that part for me, please, Ms. Archer.
The right to insure
Thanks.
against fire is only to the extent of 2/3 of
Yes.
the reinstatement value. And I know some banks have different procedures.
We require that the customer insure against all perils, including flood, and it's for the full replacement value based on the appraisal report.
But you don't do an appraisal report every year. Isn't it every 3 years?
Right, so when they initially take out the mortgage, they're to insure it for the full replacement value at that time against all perils, and that should be maintained going forward. And if it's not, if they don't provide proof annually that the property is insured, then the bank has a right to add that cost to the mortgage and pay the premium directly to the insurance company.
Mm-hmm. Yeah. And now for those who haven't paid VAT, they have to come in now and add VAT.
It's actually what I'm trying to figure out, like, when there's a conflict between the law and the bank, does the contractual relationship take precedence as opposed to the law itself? Like in a case like this where they only, I guess, it's 2/3 of the reinstatement value. When you sign the contract, you sign it for the full amount. Does the contractual relationship take precedence?
Yes.
Oh, okay.
Mm-hmm. That's the whole point of binding someone in a contract, because those are the terms. Those are the general terms. You see, whenever you sign a contract, you have that mortgage deed. And then sometimes you have supplemental documents. And that's why you need to read all the documents that relate to it. So as the bank changes its policy, they have to make sure that the provisions that within the mortgage deed are given the same implication as what the policy says. Then the bank has to write the TAC. The mortgagee as a secured lender has the right to add further monies to the security so that the monies are also secured. And they have the right to appoint a receiver. And that's to collect rents from the tenants on behalf of the mortgagor as his agent. The receiver's cost will be a debt to the mortgagor, and the terms of the appointment may exclude a bank's liabilities for monies it does not receive. And then the bank has the right to consolidate. The bank may consolidate mortgages, although banks take all monies mortgages, which eliminates the need for separate mortgages. So in your mortgage deed, they should have what they call an all monies clause. Everybody familiar with that, right? Gotta read. So what is the specific duties of a bank as a mortgagee? One, the first thing is to give investment advice. So when a bank gives investment advice, like I said before, it owes a contractual duty. And they can also be sued in tort. So their duty is to give reasonable care when they are giving advice to their clients, because they can be sued for negligence. The duty to take reasonable care in providing advice is more pronounced where the banker advertently and personally assumes the responsibility of volunteering investment advice, and then the customer relies on the statements that the banker makes. And if that customer incurs a loss, they will sue the bank. Where the ordinary business of the bank does not include providing advice on the viability of projects for which the bank is lending money, the customer may make it clear to the bank that his advice is being sought and not make a mere request for a loan in order for the bank to be under a duty of care to the borrower and potentially liable for negligent advice. So you have to be very careful when a customer asks you a particular question. Because you have to see whether or not he's asking a question, or is he asking you a question to make a statement or question to give financial advice. So notwithstanding the foregoing qualification, banks must be prudent and aware that in merely providing information to the customer, they are still under duty of care to ensure that the information provided is accurate. The legal principle is particularly important since statements made by bank officers who have actual or apparent authority to make those statements in the ordinary course of doing their day-to-day work without any effective disclaimer, and upon which a customer may reasonably be expected to rely, will attract liability to the bank. So you have to be very careful when you advise a client, because then the bank becomes liable. There are established recent decisions that have held that a bank may also be liable for contributory negligence in lending cases to other professionals, such as the appraisers or attorneys, whose advice has supported lending which caused loss to the mortgagee. The second is the exercise of the power of sale. The mortgagee has a limited or equitable duty to the mortgagor and any guarantor of the mortgage's debt to take reasonable care to obtain the true market value of the property at the date on which it decides to sell. The mortgagee does not have a duty to take any action to preserve the value of the security in the exercise of its security rights ahead of obtaining possession and control of the property subject to the mortgage. The bank does have a duty to account for the proceeds of the sale of the mortgage property, since it is a trustee for those proceeds for the beneficial interest of the mortgagor. And of course, they have to pay the mortgage or any surplus. Who had the case of Finco and Teresita? Somebody had that. Where's my
Me.
sheet? All right, tell us about Finco and Teresita.
Wow, okay. Oh, golly. So I just need to pull up the case. I don't have a retentive memory like Mr. Fountain.
He probably had that written down.
Okay. Smart. Just bear with me a second. Oh, come on. Okay, so in the case of Finance Corporation of Bahamas Limited, Finco, the plaintiff, and Teresita Sheena Johnson, the defendant. This case was heard before the Honorable Mr. Justice Keith Thompson, and appearances were made by Audley Hanna of counsel for the plaintiff, Michael Sanders of counsel for the defendant on record, and Teresita Johnson, pro se. And that meant that at one point she defended herself. Okay, and the dates of hearing, March 13th, 2019, June 25th, 2019, August 6th, 2019, November 8th, 2019. And the genesis of this matter, striking out Order 18, Rule 19, duty of mortgagee on sale of property. So this matter was commenced by a specially endorsed writ of summons filed August 5th, 2015 by the plaintiff. And the plaintiff claimed the said total principal sum of $13,472.47, interest on the outstanding principal sum pursuant to Civil Procedure Act 1992 from the 30th of July 2015 until payment or judgment. Alternatively, damages, cost, further or other relief as the court may deem just. And in this case, a summons for leave to enter judgment in default of appearance or defense was filed on the 7th of November 2017, despite the fact that the defendant was initially represented by counsel. The defendant once again appeared pro se. The defendant was successful in having the summons for judgment in default of appearance dismissed without prejudice to the plaintiff to refile. An amended writ of summons was filed November 11, 2015. Subsequently, the summons filed the 7th of November 2017 was served, and a defense was filed October 23rd, 2015. Arguments were presented on appeal by the plaintiff, and the plaintiff succeeded in setting aside the deputy registrar's decision, and the hearing for the striking out commenced. Let me just go to the meat of the matter. And the main issue of the defendant appears to be that the plaintiff, Finco, obtained an appraisal of the subject property, which pegged the market value at $105,000, but they only sold the property for $70,000. So the defense, which would be Teresita Johnson, she filed a defense claim October 23rd, 2015, which set out bare denials to the statement of the claim. What is ironic is that during the hearing of the summons to strike out, the defendant admitted that she discontinued payments from in or about 2011 due to being unemployed. However, in her defense, she denies paragraph 5 of the amended statement of claim, which provides, in breach of the terms of the mortgage, the defendant failed to repay the loan to the plaintiff in the agreed terms and fell into arrears under the mortgage. The defendant's position was that the initial writ of summons did not comply with Order 73, Rule 2. The writ of summons having been amended, I am therefore of the opinion that the amended writ of summons satisfies the requirements of Order 73, Rule 2, which provides every statement of claim in a money lender's action, whether endorsed on the writ or not, must state the date on which the loan was made, the amount actually lent to the borrower, the rate % per annum of interest charged, the date when the contract for repayment was made, the fact that a note or memorandum of the contract was made and signed by the borrower, the date when a copy of the note or memorandum was delivered or sent to the borrower, the amount repaid, the amount due but unpaid, the date upon which such sums or sums became due, and the amount of interest accrued, due, and unpaid on every such sum. The application is pursuant to Order 18, Rule 19 of the Rules of the Supreme Court, which provides the court may, hold on. The court may at any stage of proceedings order to be struck out or amended any pleading on the ground that it discloses no reasonable cause of action or defense, as the case may be. It is scandalous, frivolous, or vexatious. It may prejudice, embarrass, or delay the fair trial of the action. It is otherwise an abuse of the process of the court. And the law states, it is the court's opinion that it is strike law that in striking out applications, the starting point should be as set out in Order 18, Rule 19/3, which provides the summary procedure under this rule can only be adopted when it can be clearly seen that a claim or answer is on the face of it obviously unsustainable. It is also strike law on strikeout applications that the court is to look at the pleadings only and not to seek to try the substantive issues. In the case of Barclays Bank versus Clark, 1998, Dunkley J. stated, but the defendant must condescend upon the particulars in their evidence and should deal specifically with the plaintiff's claim and affidavits and state clearly and concisely what facts are relied upon in support of their defense. A general denial will not suffice. Sufficient facts and particulars must be given in the affidavit evidence of the defendants to show that there is a tribal issue. In the case of Guano Berry Investments Limited versus Farmilo and another, Lyons J. stated at paragraph 25, I appreciate that the older cases say that a great deal of circumspection should be applied to these applications, and that a pleading should not be struck out unless it is perfectly clear it cannot succeed. More recently, the new culture permits courts in the overall public interest of having efficient court systems to be more aggressive in striking out offending pleadings. Our new Order 31A places greater emphasis on the judge managing the case and making decisions to get the case moving effectively. This must imply a power on applications to aggressively deal with pleadings, which offer little prospect of success and if pursued would amount to a waste of time and an abuse of process. The defendant in the instant matter has only provided a bare defense in virtually every paragraph. The defendant, having admitted in court that she ceased making payments sometime in 2011, can hardly be heard to say that she has a defense to the action itself. The plaintiff is a mortgagee seeking to exercise its power of sale under a mortgage deed, and the principles relating thereto are clearly set out by Fraser J. in Evans versus Commonwealth Bank Limited and another, where she relied on the dicta of Dunkley J. and set out the relevant factors to be considered at paragraph 29 as being in First Caribbean International Bank and Dr. Hiram Mitchell and Carla Lockhart, acting Justice Dunkley, as he then was relied on the following principles contained in the case of Cuckmere Brick Co. versus Mutual Finance. The mortgagee must make an informed judgment, and because judgment is required, there are no steps which the mortgagee must definitely take. Generally, it is for the mortgagee to decide on the manner of sale. If appropriate, after having sought expert advice, the property should be properly advertised, that is, advertised sufficiently frequently and sufficiently widespread to reach the appropriate pool of prospective purchasers. The mortgagee is entitled to decide the length of time the property should remain available for sale. Subject to this, the property must fairly and properly be exposed to prospective purchasers. The mortgagee is not under a duty to improve the property for sale. The mortgagee is not under a duty to pursue or obtain a planning permission. And it seems to me, by parity of reasoning, the mortgagee is under a duty, in a case such as this one, to remove encumbrances like the grant from the property. But a mortgagee is under a duty to bring to the attention of prospective purchasers potential advantages that might be achievable, so that, for example, prospective purchasers are to be informed of the property's development potential. Where the sale price is just above the sum required to discharge the mortgager's outstanding debt, the court will scrutinize the sale with particular care. There is recognition that the fact of repossession can taint the property, so resulting in it only being capable of sale at a reduced price. And the other three items that were highlighted, the mortgagee will not have breached his duty unless he is plainly on the wrong side of the line. The mere fact that a higher price might have been obtained does not inevitably mean that the duty has been breached, and the burden of proving a breach of duty by the mortgagee rests on the mortgagor. Based on the facts of the instant case and the principles set out above, I see no basis on which the exercise of the plaintiff's power of sale can be either questioned or fettered, save and except only in the event there existed some doubt as to the propriety of the mortgage transaction itself. I found no such question or issue. In the case, sorry, one second. Right up to my glass. Can't do it.
Did we lose her?
Hello? Hello?
Hi.
Sorry,
Same
what?
to still Miss Archer is off as well.
Oh,
Oh, wow.
okay. Sorry, I didn't realize I wasn't there.
Okay, in that case, I say good night.
Miss Archer call dropped.
Yeah, the presenter call dropped away. So
She's the
Marissa?
host. Yeah, that's true too.
No, I'm here.
Oh, Marissa, you still here?
Yeah, I'm
Yeah.
here.
Oh, you're here.
Miss Archer's back.
Okay.
Okay.
Yeah.
Okay, sorry about that.
That's okay.
I'll just read the ending.
You're almost at the end now.
I'm at the end. In light therefore of the authorities and in all the circumstances and pursuant to the plaintiff's summons filed on the 16th of July, 2019, I hereby order the following. An order that the defendant's defense and counterclaim filed herein on the 23rd of October, 2015 be and is hereby struck out pursuant to Order 18, Rule 19 of the Rules of the Supreme Court and or under the inherent jurisdiction of the court on the grounds that 1, it discloses no reasonable defense. 2, it's frivolous and vexatious. 3, it's an abuse of the process of the court. An order that the plaintiff be pursuant to Order 14, Rule 1 of the Rules of the Supreme Court and is at liberty to enter judgment against the defendant for 1, the sum of $13,472.47. 2, interest on the said sum. 3, damages. And 4, cost of the action to be that of the plaintiff to be taxed if not agreed. And that was ordered on the 30th of June, 2020 by the Honorable Justice Keith Thompson. Thank you.
So this matter
Sorry
took
for
how
the
long?
snoring by my husband, sorry.
This matter took how long?
This matter commenced in 2015
And finish in 20?
and 2020.
Okay. 2020. So you see that case, remember when we first were talking about the remedies and I told you this case of Cookmare is a very important case.
Okay.
So when I start talking about the bank exercising its power of sale and true market value of the property, this case will always come up.
Okay.
This is a case of Cookmare Brick and Mutual Finance Limited.
Yes.
Okay. Now I missed one. Katora, you had Colonial Mutual Insurance? Because I think I sent the link for that.
So Ms. Archer, going back to that case, who aired in that?
This one would be just did just now?
Yes, ma'am.
Oh, well, of course it only could
The
be that.
value.
She didn't have an attorney. She did it herself.
Oh, okay. Oh, that's okay.
Yeah,
Wow.
she had an attorney on record, but then she did it herself. And when she admitted that she hadn't paid the mortgage for that period, that was it for her.
That's it.
Yeah.
All right, that was 4 years.
Yeah, that's why he said it was frivolous and vexatious. You wasting the court time.
What's her name again, please?
Teresita
The case
Sheena Johnson.
versus Finco.
Finco versus her.
All right, thank you.
Yeah, Finco sued her. So we all know for real property tax, that is the first obligation that you have to pay. And Section 7.5 of the Real Property Tax Act speaks to assessing the property every 10 years. I know that since they've gotten their new little toy flying about, they probably decided they're going to do it more frequently, but the law states that it's every 10 years.
Sorry, say that again, Ms. Aja?
Under the Real Property Tax Act, Section 7, subsection 5, it says that real property taxes can be assessed for 10 years retroactively.
Okay,
And then under Section 19, subsection 1 and 2, it states that where property is mortgaged under mortgage deed, executed either before or after the coming into operation of the section, the mortgagee of the property shall obtain from the chief valuation officer a statement as to the amount of tax or surcharge relating thereto, due and payable in respect of that property. And in any case where tax remains unpaid, the mortgagee is deemed also to be the owner of the property for the purposes of the provision of the act. So where mortgagee is deemed to be the owner of the property, the mortgagee shall pay or cause to be paid the amount of tax or surcharge as the case may be, due and payable under the provisions of this act in respect of the property. So that's why you see the government is busy collecting its taxes. On a strict interpretation of the foregoing section, it appears that the mortgagee is deemed to be the owner of the reference mortgage property and liable to pay any outstanding monies or any outstanding monies due and owing in relation to real property taxes assessed on the property. Such liability or legal obligation should not in itself deter in any way delay the sale of the reference mortgage property, as the prospective buyer may agree in some cases to accept liability for the payment of outstanding real property taxes on the mortgage property only after the sale and subject to receipt of some indemnification or guarantee or assurance on the part of the mortgagee as to the perfection and efficacy of the security interest being sold. So that's why you see the government is there fervently collecting real property tax. So the liability of a mortgagee can be liable if one of the parties to the contract states that they executed the contract under undue influence. So undue influence is an equitable principle where contracts or gifts which are made or given on the premise that one party has obtained a benefit by reason of the exercise of influence over another person. So that's why when you see husband and wife come in to sign documents, you normally ask them to get an independent legal review. Because what you don't want is for after the contract is signed, for one of the partners to claim that they were forced to sign that contract. So banks should be particularly aware of the concept of undue influence, as a third party spouse, a parent, or a child may grant a guarantee or other security to it over the family home to support the borrowing of the contracted party, of the primary borrower of the bank. If the primary borrower defaults and the bank commences proceedings for possession and exercise of the power of sale, the guarantor may allege that they were under some undue influence. And that could be either by the primary borrower over the guarantor or the primary borrower over the spouse. So mistake. A mistake will not affect the validity of the contract between the banker and the customer unless it is a serious mistake. So a mistake may be made to the subject matter of the contract, the signing of written documents, and the identity of the parties. And where mistake is proven to have occurred, the contract is considered void. So in order for a bank to recover money paid by mistake, certain conditions have to be satisfied. The bank pays a customer's money to another person on a mistake of fact. And that fact means that they would have reviewed the signature and in their belief, the signature was genuine. Or having believed that a payment has not been stopped when it has been stopped. So there's no requirement to prove that the bank was negligent in paying the amount, only that it has been mistaken in doing so. The second condition is the bank pays without the customer's consent, particularly where there are insufficient funds, believing that there are sufficient funds to cover payment, or pays a stop check, believing that no countermand is in place. Third is where the bank pays a check and later attempts to recover the funds, but does not act with great speed. Now, a bank may not be able to recover funds. A, it made a representation to the payee that it was making a payment, and the payee changed his position in good faith, and to his detriment as a result of receiving the payment, or the bank paid another bank as a collecting agent for the payee, and the payee has withdrawn the funds. A paying bank can only collect from the payee and not the collecting bank. So where the paying bank is unable to succeed in recovering the paid funds due to a mistake of fact, it may be able to exercise and enforce its proprietary right to trace the funds. A customer is also entitled to reclaim monies paid under a mistake of fact. So where a bank has mistakenly credited a customer's account, it may redebit the account or reclaim any funds that the customer has withdrawn from the account. The bank may be stopped from recovering the funds if the customer changes his position in good faith as a result of the credits being mistakenly made by the bank. So that means that if a customer is expecting $5,000 on his account tomorrow, he's expecting those funds, and here's evidence to prove that his uncle is sending him $5,000 tomorrow. So when tomorrow comes, he sees $5,000 on his account, not knowing that it is not from his uncle, but that the bank made a mistake. He withdraws that $5,000 and he spends it. Then the bank cannot prevent him from using those funds, and nor can it recover it. The only thing it can do is to enter in the conversation with the client to say, when you actually receive those funds, we're going to take those funds from you.
Ms. Archer, repeat that again. You're saying that the bank can't go after him for it?
No,
Can't recover it?
no.
If
If
he
he-
took, he's
if-
expecting monies from his uncle, who didn't happen to send the money the same time he
He
think
would
it's money.
would not have known that.
Yeah, he would not have known it. Okay, so when he comes in and the bank says to him that, hey, that $5,000 you was getting from your uncle, that's not the $5,000. The bank cannot go after him?
No. In banking law, they are prevented from doing so, because he would have withdrawn those funds in good faith, because he was expecting those funds.
Say what?
Yeah. And as a result of him doing that, his position in life has changed. So he has to prove, one, that he was expecting those funds, two, that he didn't know that those funds were not his, and three, that his position in life had changed. And the case is United Overseas Bank versus Giovanni. Mm-hmm.
So then if the bank cannot go after him for it, hence the bank cannot put a hold on his account should that money, let's say the uncle never sent the money.
Then you're gonna have to have a discussion with him, because if his position has changed, his position in life has changed due to those funds, you cannot get that money back. So he has to be able to prove that his position in life has changed. He can't take that money and go to the grocery store. That's not a change in position in life.
So then it would have to be what is a change in position in life. Like, let's say, for example, if you take that money and get a car, the car that he so needed. So
That's a
why?
change. Yes. Mm-hmm.
So let me just ask another silly question in terms of if he, like, what would be his proof that the uncle was going to send him the money? Then
But he should have communication.
communication meaning that him and the uncle talk and the uncle said, I'll send you the money, but the uncle never got around to sending the money. For $5,000, it so happened to be the same amount that he was expecting, but the
Yes.
uncle never got to send in the money.
Right.
Meaning that the bank can't go after him for the money that he thought he would have received.
Yes. If his position has changed in good faith.
That's all right. Righteous.
No, but see, the thing about it is, it's just like how you read in these cases. He has to prove, one, that he was expecting these funds. And whatever he did with the funds, he had to do it in good faith. Remember how the judges work now? They listen to when you answer their questions. And they can tell whether or not what you did was in good faith.
Let me just use an example. I had a client whose landlord was supposed to refund her some money.
Mm-hmm.
She came in and found out that some money was to her account. She automatically assumed that that was the refund that the landlord was sending. It was short of what it is she was expecting, but she assumed that that was the money the landlord was sending to her, and hence she removed the funds, and it was a posting error on our behalf. So in that instance, you're telling me that we can't go after her for removing those funds. That was
Yes, you
not
can.
her money.
Yes, you can. The thing about it is when those funds that she was expecting, those funds had to be used for something that changes her position in life. So what was she expecting to do with those funds?
She wanted to rent somewhere else. And that's
And
what she did.
And she did rent.
Yes.
And she did that in good faith. She wholeheartedly felt that that was the money that she was expecting.
Right.
But then, like I said, it's based on the judge, whether or not the judge believes so or not.
But even anyways, I guess that's the law, but that don't make no sense if the money, which was not from the person whom you were expecting it from, if that never happened.
But how would she know that? If I know I'm expecting $3,000 tomorrow, and I look on my account and I see $3,000, and I know with that $3,000 I was going to buy a car, how would I know that $3,000 didn't come from there?
Yeah, that's what I'm asking you in terms of once the bank would have called her in and say, you know, that $3,000 did not come from your uncle, right? And the bank showed that the $3,000 never came from the uncle. She calls the uncle said, I did not get around to sending the money.
Mm-hmm.
Yeah. And,
yeah.
and saying based on the law, because she believed the uncle would have sent the money, we can't go after her after discovering, and her uncle said that he didn't send the money. So after discovering that's not the same $3,000, you're saying that we can't go after her for it?
Yeah, you can take her to court, and I'm saying the judge will then determine whether or not her position changed in life and what she did, whether she did it in good faith.
Okay, so okay, I got what you're saying. So let's say it's all done in good faith because she did use the money to rent the place, which changed her position in life. And then the judge may rule to say, well, again, to me, all of it is who the judge is and what they're feeling at the time. That's how I feel the law. That's how I feel the law is. Whoever the judge is. So then the judge will say, well, go back to the uncle and get the money. Or the judge will say, well, you know, she did it in good faith and it changed her position in life. So it was your negligence and your posting error. And so I'm so sorry. It depends on the judge.
Depends on the judge, as you can see as we go through the cases.
Yes, yes. All right.
But I mean, some people would automatically say, yes, I was expecting that sum of money. I used it, but the funds will be here tomorrow, next week. My uncle said so and so, so when I come take it off. Some people are like that.
Some people are like that, and then the others, like the same woman I had to lock her account down, who says, well, it ain't my fault.
Yeah, and that's when you love to take it to court. And see, and just by that attitude, it's telling you that raised the question whether or not she did it in good faith.
Right, and I guess depending on the judge,
Mhm.
they look at the woman and say, okay, she lying, just like in the Jane case. Oh, gosh. Okay,
She's
thanks.
It's the one who's going to have to prove.
Right.
She has to prove.
Okay, thanks.
Yeah, she'll have to prove. So the next one is misrepresentation. And that's when there's a false statement of a material fact made by a party to a contract or its agent, which induces the other party to enter into the contract. And so there are three different types of misrepresentation. There's innocent, negligent, and fraudulent. Innocent, and that's where there's a false statement made by a person who had reasonable grounds to believe that it was true when he made it and at the time when the contract was made. The negligent one is you make a false statement and you had no reasonable grounds for believing that statement to be true. Or it could be a fraudulent statement, and that's where you make a false statement by a person who knew that that statement was false, or they believe it to be false, or they just didn't care whether it was true or false, and they just make the statement. The parties to the banker customer contract may rescind the contract where any of the foregoing types of misrepresentation exists, and damages are available for fraudulent misrepresentation under the tort of deceit. Negligence is a tort where there is an omission to do something which one has a duty or obligation to do, but fails to do. To prove negligence, the defendant must have owed a duty of care to the plaintiff. The defendant must have breached that duty to the standard of a reasonable man, and the plaintiff must have suffered some loss or damage as a result of the breach of duty. Banks have to be careful to avoid negligence by making negligent misstatements. So where there is a special relationship between the parties and one of the parties relied on a particular skill of the other party and suffered some loss, and the other party knew of this reliance, of course, you get our professional negligence. Now, the duties and liabilities and rights under the Homeowners Protection Act. There is the obligation to give notice prior to exercising the power of sale. The mortgagee must give a 30-day notice in writing prior to either instituting court proceedings or exercising non-judicial power of sale. The mortgagee must not engage in unfair, deceptive, or abusive acts or practices. Where a mortgagee has failed to secure a sale of the mortgage property at market value within 6 months of either issuing a notice of default or having obtained vacant possession, the mortgagee, at his option, may serve notice that it intends on accepting the highest qualifying bid offered in writing. The notice must include that the property may be sold at less than the market value and that the mortgagee may pursue the mortgagor where there is a residual debt after the sale. The mortgagee may be barred from pursuing the mortgagor where there is a shortfall in sale if at the date of the sale either a sum equal to at least 1/2 of the principal and accrued interest has been paid to the mortgagee, or the mortgagor has been in occupation of the dwelling house for a period of not less than 50% of the original mortgage term. So within 10 days of receipt, of the mortgagee's notice, the mortgagor has the right to issue a notice of objection, stating his intention to either pay the amount of principal and interest at a specified time, remedy any default consisting of any breach of any obligation arising under the mortgage, or apply to the court for relief. Should the mortgagor fail to issue a notice of objection, the mortgagee may take the required steps to sell the mortgage property. The provisions of this section shall apply to all mortgages, notwithstanding any provision in any other law or custom, or any clause contained in any mortgage document executed before or after the coming into effect of the Homeowners Protection Act. The mortgagee shall not sell the mortgage property to any of the following parties: a director or employee of the financial institution, any immediate family of a director or employee of the institution, a company beneficially owned by a director or employee, or any person who, by the nature of their intimate relationship with a director or employee of the financial institution, would be given more favorable consideration as a result thereof. So the conveyance from the mortgagee to a purchaser pursuant to the exercise of the power of sale must contain a clause reciting the mortgage document, and that the mortgagee has exercised his right to sell after giving notice to the mortgagor. The effect of the above recital is to bar all equity of redemption of the mortgagor or his successors in and to the mortgage property. The mortgagee shall be exempt from paying 50% of any sums due and owing under the Stamp Act on the sale of a mortgage property in instances where the mortgagee sells the property under the power of sale within 5 years of the date on which the last advance was made by the mortgagee. The mortgagee must respond to a mortgagor's written request for a statement of account within 30 days of receipt of the request. The mortgagee must supply the said statement free of charge up to twice in any calendar year. And if the mortgagee fails to respond without having a reasonable excuse, any rights that it may have for the enforcement of the debt will be suspended until they have provided the mortgage statement. And this relates only to those proceedings initiated after the coming into effect of the Homeowners Protection Act. Where mortgagor exercises his entitlement under Section 17 of the Conveyancing and Law of Property Act, the mortgagee must assign or convey the debt to the new lender without requiring the mortgagor or the new lender to pay any costs associated with it. If the mortgagee transfers, assigns, or sells the mortgagor's debt, the mortgagee must advise the mortgagor in writing not less than 30 days before the effective date of the transfer or the assignment or the sale. The notice must be served either personally or by registered post. A financial institution that contravenes or fails to comply with any provision of the Homeowners Protection Act commits an offense and is liable to a fine of $200,000. A director of a company who knowingly concurs in the contravention or failure to comply with the act is liable to a fine of $100,000. And notwithstanding any penalties that may be imposed under the act under Section 20, a financial institution that contravenes any provision can be fined up to $200,000 as an administrative penalty, and a director $100,000. Previously, judgments granted by the court with respect to mortgages were not subject to an expiry date. However, with the coming into effect of the Homeowners Protection Act, mortgagees are statute barred from recovering any sum owing under such judgments after either the expiry of 6 years from the date on which the judgment was obtained or the date of the last payment pursuing to the judgment. Who had BOB versus Herman Maycock?
I did.
Okay, are you ready?
I was looking at the time. Okay, I can do it.
At 8:36, you can be quick.
Okay, no problem. Okay, so okay, in the case of Bank of the Bahamas Limited, the plaintiff versus Herman Cleophas Maycock, the first defendant, and Sabrina Elizabeth Maycock, the second defendant. The hearing date was the 11th of February 2021 and the 5th of March 2021. On the civil side, enforcement of judgment, writ of possession, application to invalidate writ of possession, Section 5.3 and 38.5 Limitation Act, Chapter 83, Order 46, Rule 2.1, Section 23.3 Homeowners Protection Act 2017. The particulars of the case are that the first and second defendants obtained a mortgage loan from the plaintiff on December 17th, 2010 in the amount of $273,000. The purpose of the loan was to purchase a commercial fishing vessel, and they pledged their primary residence located lot 314 Eastwood Subdivision as collateral for the loan. The terms were that the loan was to be repaid over 15 years at an interest rate of 8% with monthly payments of $2,770. The first defendant, Herman Maycock, was responsible for making over-the-counter payments of $1,400 per month. While the second defendant, Sabrina Maycock, had an automatic salary deduction in place for the difference of $1,370. This deduction continued up to the time of the current legal proceedings. Mr. Maycock experienced adverse changes to his financial circumstances, and although Mrs. Maycock's salary deduction was still ongoing, the loan eventually went into default. As a result, the plaintiff, BOB, commenced legal proceedings by filing an originating summons on April 3rd, 2012, asking the court for the following relief. Payment of the sum of $268,184.31 that was broken down between principal sum outstanding, accumulated interest, and late fees. They also asked for delivery by the defendants to the plaintiff, possession of the mortgage premises. The Maycocks were not at the hearing of the originating summons and later claimed that they were never served notice of the proceedings. However, by virtue of an affidavit of service sworn by Constable 3990 Fritz Nell Pierre, there was evidence before the court that the first defendant, Mr. Maycock, was personally served at his residence on July 19, 2012 at 7:45 p.m. In their absence, judgment was granted by the court in favor of the plaintiff against the first defendant as follows: that the said Herman Cleophas Maycock, the first defendant herein, do pay the plaintiff the sum of $268,184.31, which was made up of the principal sum outstanding, interest thereon, and penalties, late fees, etc. He also advised that Herman Maycock was to deliver possession of the home, lot 314, to the plaintiff, and that costs were to be for the plaintiff to be taxed if not agreed. During the period 2012 to 2016, there were various discussions and proposals between the parties for the restructure of the debt, but a restructure did not materialize. Although the action was commenced in 2012, the defendants claimed that they did not become aware of it until July 2016 and were not aware that a judgment in favor of the plaintiffs had been granted. In early 2019, the defendants became aware that their home had been advertised for sale in the newspaper and contacted the plaintiff. Arrangements were made for a meeting and the defendants made an offer of $250,000 to settle the outstanding debt, which the plaintiff accepted. However, the defendants were not able to secure financing with another financial institution to raise the sum, and subsequently, the plaintiffs advertised their home in the newspaper again in 2020. On various dates during the period 2016 to 2020, a writ of possession to enforce the judgment was issued by the plaintiff against the first defendant. The most recent writ, the 2020 writ, which was issued on the 28th of September 2020, was the subject of the defendant's application. Arguments made by counsel and disposition. So in the first instance, the defendant's attorney, Mr. Nichols, argued that the judgment obtained in 2012 by the plaintiffs could not be enforced because pursuant to Section 5(3) of the Limitation Act 1995, the limitation period for enforcing the judgment had expired. The Act states an action shall not be brought upon any judgment after the expiry of 6 years from the date on which the judgment became enforceable, and no arrears of interest in respect of any judgment debt shall be recovered after the expiry of 6 years from the date on which the interest became due. Mr. Nichols cited the case of Perfect Luck Investments and another 2017, whereby it was determined that an action under Section 5(3) is not limited to fresh actions on a judgment, but also includes proceedings to enforce a judgment, and invited the court to follow the decision in this case accordingly. The plaintiff's attorney, Mr. Davis, submitted that the defendant's application was misconceived. He contended that the enforcement proceedings are not barred by Section 5(3) of the Limitation Act and relied on the decision of the court in Bahamas Commonwealth Bank Limited versus Lewis and Imperial Life Assurance of Canada versus Wells, both of which predated Perfect Luck. Mr. Davis argued that the decision in Perfect Luck was made on a vendor purchaser summons and advised that the other cases noted above were more applicable in the current proceedings. He further argued that even if Section 5(3) of the Limitation Act was applicable, the limitation period for enforcing the judgment was extended by Section 38(5) of the Act and Section 23 of the Homeowners Protection Act 2017, because the defendants continued making payments on the judgment debt via the salary deduction from the second defendant. And that portion of the Act says that subject to the proviso to subsection 4, a current period of limitation may be repeatedly extended under this section by further acknowledgements or payments. But a right of action once barred by this Act shall not be revived by any subsequent acknowledgement or payment. Section 23(3) of the Homeowners Protection Act states no mortgagee shall recover from any mortgagor any sum owing under any judgment by the court for the repayment of any sum borrowed by the mortgagor from the mortgagee after the expiry of 6 years from the date on which the judgment was first obtained or the date of the last payment pursuant to that judgment. The court stated that after reading the case of Perfect Luck, it agreed with the plaintiff's attorney that that case could not be applied to the present case. In the case of Perfect Luck, the plaintiffs, which were the vendors, made application to the court for declarations to be made in the following terms: that the right of a judgment creditor under a judgment which operates as an equitable charge to bring an action or proceedings for enforcement of that judgment is barred after the lapse of 6 years by virtue of Section 5(3) of the Limitation Act. And secondly, that the requisitions raised by the defendants, which were the purchasers, had been reasonably answered by the plaintiffs. The requisitions raised by the defendant were with regards to various judgments entered against the Hotel Corporation and other predecessors entitled to the property subject to sale. More than 10 years had elapsed since the date of each of the judgments, and the defendants wanted to confirm the time period within which the equitable charges created by the judgments would be enforceable. Justice Winder, in determining his judgment, relied upon the ruling in the House of Lords in Lousley versus Forbes and granted the declaration sought by the plaintiff. The judge further declared that the savings under the Homeowners Protection Act were better applied to the current case before the court, and that by the defendant's own evidence, monthly payments continued to be made to the plaintiff up to the time their affidavits were sworn in December 2020. He stated that in law, the payments are deemed to be made pursuant to the judgment, and as such, in accordance with Section 23(3), the period for recovery by the plaintiff of the judgment debt was repeatedly extended, and it was not expired on the date the 2020 writ was issued. It was well established that the plaintiff, as mortgagee, may enforce the judgment by taking possession of the mortgage property and exercising its power of sale. He was of the view that 5(3) of the Limitation Act did not apply in this instance and declined to make a declaration that the 2020 writ was invalid. The defendant's attorney also argued that the 2020 writ was invalid because there was evidence that the plaintiff failed to obtain leave to issue the writ in accordance with Order 46. The plaintiff's attorney submitted that the order did not apply to a mortgagee because of Order 45. Rule 3.2 provides that no leave is required for the issuance of a writ of possession to enforce a judgment made in a mortgage action such as this. However, he stated that if leave was required, the plaintiff's failure to obtain leave was a mere irregularity by virtue of Order 2, Rule 1, and the court should permit it to stand. The court stated that the purpose of the rule was to do away with distinctions between nullities and irregularities. In the present case, the issuance of the 2020 writ without the requisite leave is a proceeding within the scope of the Order 2, Rule 1, and was treated by the court as a mere irregularity. The court therefore declined to declare that the 2020 writ was invalid, that is, that it had no legal force. The court then stated that the question posed is whether it should allow the writ to stand as a period of 6 years had passed since the judgment was obtained by the plaintiffs, and the decision was based on the reason why the judgment was not enforced during that time. The court determined that the delay was due to the plaintiff attempting to work with the defendant by discussing a restructure and even agreeing to a short sale of $250,000. The court determined that the plaintiff should not be penalized because of its willingness to accommodate and work with the defendants, and ordered that the 2020 writ do stand. The final defense lodged by the defendant's attorney was that the plaintiff should be stopped from seeking to enforce the judgment because they entered into an agreement for the settlement of the mortgage debt subsequent to the judgment and thereby waived its rights to enforce the judgment. And secondly, the defendants were not served with the notice of the hearing of the originating summons. The plaintiff's attorney submitted that the agreement to accept the $250,000 did not create an estoppel, as no consideration passed from the defendants to the plaintiffs and no sum was paid by the defendants. The judge agreed with the plaintiff's attorney that the circumstances necessary to create an estoppel did not arise in this case. With reference to the defendant's complaint that they were not properly served, the court believed the evidence given by Constable Pierre that he did serve the first defendant at his residence, and in any event, that the defendants became aware of the proceedings in 2016, but failed to take any steps to appeal or otherwise impeach the judgment. The court concluded that the plaintiff's right to enforce the judgment was not statute barred at the time of the issuance of the 2020 writ, and the 2020 writ was not invalid. It was ordered that the validity of the 2020 writ be extended to the 28th of April 2022 to make up for the time which had elapsed between the filing of the defendant's application and the date of the ruling. The plaintiff was to have its costs taxed if not agreed.
All right, so Mr. Makoff lost. Yes. So you see how these cases turn, right? This was on the Homeowners Protection Act, yes. Because I know several persons who tried to get out of it by using this clause 23(3), because they thought that the 6-year period had passed. But in 2 of those cases, they were not statute barred. And they lost their homes. It's kind of sad, but that's what the law is.
So
That's sad
case
because they
closed.
remortgaged their homes to get, was it both? or something.
A commercial fishing vessel.
Commercial fishing, yeah, some fishing vessel, that's sad.
It is, and they defaulted within like about 2 years. It wasn't even long.
Mm-hmm.
The wife kept up her part of the bargain, but the fisherman didn't make wasn't able to
Yeah,
deliver
I felt
his
that for
part.
her. I felt that for her.
I surely did, because the payments continued out of her salary right up until the time they went to court.
Exactly. But he couldn't keep up with his.
Probably didn't even know. My Lord.
But she should have checked.
Exactly. She may not have, because I thought it was ironic. It was the fact that they served him and they kept referring to the first defendant. I was wondering why that was.
Mm-hmm. Yeah, they never referred to her.
And it made me feel she didn't know.
But she should have checked. That means she left everything to him.
Yeah.
You know, that happens quite often.
I guess she was paying, so she was assuming, I mean, everything okay, my Lord.
But he's on a boat. You got to know if he's selling any fish or not.
Now, to lose my home, a fishing boat.
Big
Ms.
fighting
Archer,
game.
can you explain the clause 23(3) with the 6 year the 6 years that you mentioned? That clause specifically relates to what, 6 years passing, or can you help me out with that, please?
That is saying that after 6 years, see, where is it again? And that's the last thing I have there. I just moved. Okay. So the act says in section 23, subsection 3, it says, previously, judgments granted by the court with respect to mortgages were not subject to an expiry date. That was the past. But when the Owners Protection Act came into effect, mortgagees are statute barred from recovering monies under judgments after the expiry of 6 years from the date on which one was obtained. So in this instance, remember, he extended the date of the judgment. And by him extending the date of the judgment, then it didn't fall after the 6 years. Because they were trying to work things out with the Maycox.
Oh, okay, okay.
So he moved the date. So the act says that once that act came into place, the banks are statute barred from recovering money that is owed to them under a judgment after either 6 years has passed, after the judgment was obtained, or the date of the last payment pursuant to the judgment was made. So this is the caveat that the government put in to protect persons with their homes.
Okay, understood. Thank you.
Everything is based on the order. All right, so next class is understanding the mortgage process. Is my presenter on? Let me see. Who volunteered again? I think I made a note somewhere. That's my volunteer for my presentation next class. Who was that again? Oh, shoot, I didn't put down the name. Someone had volunteered. Don't go silent. Who was it?
Ms. Archie, you know, you have to keep careful notes.
No, someone volunteered. And they were excited about it. Who was that volunteer?
You know, we can always say Krista.
I just want to say Krista.
No,
What I volunteer for again?
No,
no.
honey, we just will say Krista.
No. Tried to say Krista, but it was not Krista. Who's volunteering to do the
Okay,
same?
what is it, Ms. Archer?
The same presentation they did at work. They said they did a presentation on home ownership.
Oh, and that was.
Yeah,
Didn't we
did
solve that
find
by
out.
process of elimination?
No, we did, Santina did confirm when
Santina.
I explained to her what the conversation was about. She's like, yes, it was her, but Miss Archer, I think that she has deferred the class, right?
Yeah, she did. She did. She did.
Okay, so
So we won't have that one. No one can ask her for it. So someone could present it.
or what is
We
it
can ask her
about?
for it and James will present it.
No, Stacy, you sound like you want to ask her. I'm volunteer.
I just did a presentation, so I'll
Okay,
get it
no
for you
problem, Ms.
tomorrow,
Archer.
James.
What is it about? What is it? I mean, I can ask her too.
She remembers this. She was saying she did a presentation on a mortgage, I think, versus rental.
Okay, no
Renting.
problem. We'll
Yes.
ask her whatever she has.
Yeah. And
Alrighty.
she's well received. So that's when I asked her if she wanted to present it, and she said yes. You don't have a problem.
Alrighty.
Okay.
Yes, ma'am.
So I'll see if I can find some more cases for chapter 7. Let's see. I don't think I have much on the process itself, but let me see what I could find. I could send those out. And all those who've been ducking me, don't worry. I'll put your name down again. How about that? You know you can't miss me. So I'm looking forward to some emails tonight. Once I get those emails, I will send you the question. And then for those after you get your midterm results, you could let me know which question you want to try. And then next week, y'all will let me know how you want your finals. I hear 50-50. Some say no, some say more. So let me know what you decide. How that sounds?
Okay.
Yes, ma'am.
Okay, if
Sounds good.
Y'all could figure out what you want. Probably before the next class, y'all could have a chat before we begin and let me know so I could start writing. Okay?
Okay. So you say
Okay.
Miguel will send us papers back
I'm a-
tomorrow, possibly?
I'll give it to him tomorrow and I'll tell him that you all are waiting eagerly.
Okay.
Tell him you're waiting. I'll tell him tonight, but I'll have to drop them off to him tomorrow. And I'll tell him scan and send them to you all. So just look out for it. All right. And then we'll go from there. But for those who want to do the other one, send it to me so I know who I'm dealing with and let me start to write something for you all and get a confirmation on the time from Miguel. Okay.
Okay.
All right. So have a great evening. It's 9 o'clock. Didn't mean to keep you all so late. Next week, I'll try to shorter.
Okay, good night.
No problem.
Okay.
Good night, everyone.
Good
Good
night,
night.
Good night.
Good night. Good night.
Good night.
Good,
Good night.
good night.
I can't get off the meeting.